Good morning and welcome to this morning's SICES webinar, the 10 amendments brought to you by us at Archer. Our plan today is to provide you with a whistle-stop tour of the 10 most common amendments that we see in NEC contracts. We have focused on the NEC 4, but will, where necessary, draw on the differences between the NEC 3 and 4. Just so that you know, these slides will be sent to you after the webinar and a recording will also be made available on the SICES YouTube channel. So just before we get going, if anyone who doesn't know us, we are a firm of construction solicitors based just outside Colchester and have just celebrated our 2nd birthday. There are 6 partners and we are all senior members in the construction team of a large regional firm prior to setting up Archer. We're now a 17 strong headcount and we specialise in both contentious and non-contentious construction work. So today, I'm delighted to be joined by my colleagues, Hanna McNab, who's also a partner, and my colleague, Sarah Lester, who is a senior associate. I will now hand you over to Sarah, who is going to start this whistle-stop tour.
Thank you, Ruth. So the first common amendment that we're going to cover is design responsibility. Whilst this is by no means a new topic, it remains an important one because of the significant potential and very often costly risks involved where a contractor is expected to accept full responsibility for the design of a project. Under the unamended NEC contract, the contractor's responsibility for design is dealt with at clause 21.1. And as you can see from the extracts that we've provided on the screen here, the extent of the contractor's design responsibility is determined by reference to the scope, with the contractor having responsibility for the design to the extent set out in the scope. More often than not, the scope makes the contractor responsible for the design of the entirety of the works, and clause 21.1 then tends to be amended as shown on the slide, with the effect being that the contractor is responsible for the entirety of the design contained within the scope, whether that design has been prepared or commissioned by the contractor or by the client. The unamended NEC gives the contractor an entitlement to claim additional time and money by way of a compensation event where there have been changes to the scope, and the relevant compensation event is clause 61.11. As you can see from the extract on the screen, there are some caveats to this entitlement. The contractor isn't entitled to a compensation event where the change to the scope has been made in order to accept a defect in the contractor's work, quite understandably so, or where there are changes that are necessary because of a change that the contractor wants to make to their own design, or because the scope provided by the contractor for their design doesn't comply with the scope that's been provided by the client. In effect, this means that the unamended position is that the contractor only takes the risk on the design that they have themselves provided. Under clause 60.11, this clause is often amended to reflect the amendment that we've just spoken about at clause 21.1, so this full design responsibility point, by adding a further caveat to the contractor's entitlement to a compensation event. So the contractor is then also not entitled to a compensation event where a change to the scope is required in order to resolve an error, omission, inadequacy, ambiguity, or inconsistency, and sometimes the list is even longer than that, either within the documents that form the scope or between the scope provided by the client and the scope provided by the contractor for their design. This reinforces that the contractor is responsible for the entirety of the design contained within the scope, whether that's prepared by the contractor or by the client, and it does that by preventing any entitlement to additional time and money where there are issues with that design. So as we've discussed, it's very often the case that the contractor is required to accept full responsibility for the entirety of the design of the works, including any design prepared by the client or by the client's consultants. Linked to this is another very important consideration, and that's the extent of the contractor's design liability. And by this we mean whether the contractor is required to exercise reasonable skill and care when preparing their design, and are therefore only liable in circumstances where the design has not been executed with that reasonable skill and care, or whether the contractor is expected to provide a design that is fit for purpose. We'll come on to why this is so important in a moment, but first we're going to have a look at how the unamended NEC contract deals with design liability. It's quite unusual in how it deals with it. So unlike most construction contracts, design liability is only expressly dealt with if secondary option clause X15 is incorporated into the contract. As you can see, X15.1 confirms that where option X15 is used, the contractor is only responsible for defects in their design when they've failed to exercise the skill and care normally used by design professionals. And that standard of care is reasonable skill and care. So before we come on to the common amendments made to that clause, the important thing to note about the NEC contract is that without X15, the implied standard of care may be assessed according to the common law rule, which is that in the absence of any confirmation to the contrary, the contractor will be expected to design the work so that they're reasonably suitable for the purpose for which the contractor knows that they're required. And in other words, there could be an implied fitness for purpose obligation. So where X15 is incorporated, it's often amended as shown in red on the slide. The key issues with this particular amendment from the contractor's perspective are the parts of the text that have been highlighted in yellow. Those are problematic because thanks to some somewhat interesting decisions from the courts, wording of this nature can lead to an implied fitness for purpose obligation. So coming back to that common law point, the two key cases are the ones that are shown on the slide. The first one is the IBA case, and this related to the construction of a TV mast on Emily Moor. There were high winds and ice, and that led to something called vortex shredding, and that resulted in the mast collapsing. At the time, the contractor, who was EMI, had appointed BICC to carry out the design. However, within the contract, there was no express reference to the nature of the duty of care for EMI towards IBA, who were the client. In this case, the court distinguished between a contractor's level of skill and care and the skill and care of a designer. And the court effectively said that in the absence of anything to the contrary within the contract, a contractor guarantees that the finished product is fit for purpose, and this includes the obligation for design. So what has emerged from this case is quite a bizarre situation where a contractor's duty of care for their design is higher than that of a designer. This is why it's important that any reference to the standard of care for design is that of a designer and not a contractor. The more recent MT Hogarth case considered what happens where a contract includes two differing standards of care. So this claim related to a large wind farm, which is known as the Robin Rig Wind Farm. Unfortunately, the grouting to the foundations failed. It turns out very unfortunately for the contractor. It was actually accepted that the design carried out at the time was to recognised industry standards. The issue for Hogarth was that those standards were not themselves correct. The cost of the repair was some £23.6 million, so it was a very important case for everybody involved. The key issue that needed to be decided was which standard of care applied to the contractor's design. In simple terms, there were conflicting clauses in the contract between the parties. One clause said that the contractor was to use reasonable skill and care. However, there was also a provision tucked away in a specification saying that the foundations would have to have a design life of 20 years, and that was seen as a fitness for purpose obligation. The court therefore had to decide what happens when there are conflicting terms, and they came to the conclusion that where there are two conflicting standards, the higher standard applies, and Hogarth was ordered to pay the £23.6 million. It's therefore very important to be aware of any terms within a contract that could be considered to be an implied fitness for purpose obligation. So why is this so important? Putting it simply, if you sign up to a fitness for purpose clause for design, it is very, very likely that you won't be covered for this on your insurance. So most professional indemnity policies have an express fitness for purpose exclusion, and signing up to a fitness for purpose obligation could mean not only that the fitness for purpose element isn't covered, but that the entirety of the policy is invalidated, which could obviously be disastrous. So some key points to take away then. Most NEC contracts are amended in a way that makes the contractor entirely responsible for the design of the works. This includes the design that's been prepared by the client, or more accurately by the client's consultants, and that can often be before the contractor has ever had an involvement with the project. Whilst this does significantly alter the risk profile of the contract, this is the market standard position, and we work in a market that's driven by developers, or more accurately their funders, and this is therefore not something that's likely to change anytime soon. If you're a contractor, what can you do to mitigate this risk? Well, firstly, if you are intending to rely on the information within the scope, it would be very sensible to establish a contractual link between you and the consultants who have prepared that design. This is very often achieved within the main contract itself by novating the appointment from the client to the contractor, so that the contractor steps into the shoes of the client for the purposes of the appointment. If there isn't going to be a novation, the contractor should either obtain a direct collateral warranty from the consultant for their benefit. The only real other solution is to employ a new design team and try and procure that design team takes on responsibility for the existing design, although that can have obviously can be a fairly difficult conversation. Another option is to focus on a two-stage contracting approach, so that the contractor is engaged at an early stage and can have an influence over and involvement in the design from the beginning. If you're working under an option C or an option E contract, the NEC gives you option X22, which deals with early contractor involvement, so that could be something that could be utilised. It goes without saying, really, a full review of the scope is essential. One thing that we often see contractors doing is including a derogations schedule within the contractor's scope. Most contracts that pass on full design risk make it clear that the contractor is responsible for all of the documents, including discrepancies between them. So simply including a derogation schedule is not likely to be sufficient unless you've also stated that the contract, in the contract, that takes precedence over all the other documents. So just be a bit careful with the derogation schedule. Contractors obviously have to consider how they are engaging with their supply chain, and to ensure that any design risk is where it can be passed on, and also to engage with the supply chain at the earliest stage, so that design issues can be ironed out as early as possible. And finally, the correct standard of care must be applied to ensure that there are no fitness for purpose obligations, whether those be express or implied. So moving on to our second key amendment, which is the requirement to provide additional security and collateral warranties. Somewhat helpfully, the NEC contract has decided to refer to collateral warranties as undertakings. We're going to talk about collateral warranties in this presentation because that's what most people know them as. The obligations to provide a performance bond, a parent company guarantee and collateral warranties are set out in the secondary option clauses. And whether or not these obligations apply will depend on whether the contract data incorporates the relevant X clause into the contract. So as you can see from the slide, the obligation to provide a parent company guarantee is set out in clause X4. Collateral warranties are dealt with at X8, and if a performance bond is required, the relevant clause is X13. The key amendment that is made to these clauses is set out on the slide, and that is to make provision of these documents a condition precedent to payment, and that gives the client the authority to withhold all sums due to the contractor until the documents are provided. So in terms of the parent company guarantee under X4, it's important to note that the standard NEC contract assumes that a PCG will be provided by the contractor's ultimate parent company, so an ultimate holding company guarantee. Whilst this makes sense from the client's perspective, because this is likely to be the company with the greatest assets, this might not be acceptable to the contractor. X4.2 does allow the contractor the ability to suggest an alternative guarantor, but this can be rejected by the project manager on the basis that the alternative guarantor doesn't have sufficient commercial strength. It's therefore very important from the contractor's perspective that if X4 is to apply, the proposed guarantor is agreed by the client before entering into the contract. Where X8 applies, the contractor is required to provide collateral warranties. The biggest issue for a main contractor is that the obligation to provide collateral warranties includes an obligation to procure them from the supply chain. And as I'm sure many of you are aware, this can be easier said than done. The form of collateral warranty to be provided is the form that is set out in the scope, and there is no ability under the standard NEC wording for the contractor to propose alternative wording where subcontractors do not agree with all of the terms of the proposed collateral warranty. Where the amendment to X8 shown on the slide is made, the contractor may not be entitled to any further payment where they haven't provided a collateral warranty on behalf of a subcontractor. So this is an amendment that can have some very significant commercial implications. So finally, looking at X13, if that applies, the contractor will be obliged to provide a performance bond, and that is to be in the form set out in the scope. Whilst this is not uncommon or a particularly new requirement, the bond market is incredibly difficult at the moment. So contractors need to ensure that if they are required to provide a bond, the surety providing the bond has been approved by the client ahead of entering into the contract, and the surety has agreed to provide the bond in the terms required under the contract. So given the current issues in the market with high levels of insolvency, and we're seeing that both the main contractor and subcontractor tiers, the requirement for additional security documents in the form of a performance bond or PCG or both is on the rise. This often stems from funders who will require the security to be in place as a condition of the funding drawdown. Similarly, the requirement to provide collateral warranties is extending to a greater number of parties, with there being a rise in contracts demanding what they're calling workmanship only collateral warranties. And that means the obligation on the main contractor to procure warranties extends to a far greater element of the supply chain than just those subcontractors and consultants with responsibility for a material element of the design, which is the kind of traditional approach. The key issue for the parties responsible for providing these documents is that they are almost always made a condition precedent to payment, and this is particularly problematic when this requires reliance on third parties, which is often the case. So how can a contractor manage this risk? Well, firstly, where security documents are concerned, there's often a requirement to provide both a performance bond and a PCG. Given that these documents are both principally to protect against insolvency risk, it could be argued that two forms of security protecting against the same risk is excessive. It's also important to consider whether it's actually possible to provide these documents. Provision of a PCG will obviously depend on how the company is structured, but will also be reliant on the parent company being prepared to give the guarantee. In terms of a performance bond, the contractor will need a bond facility to be able to provide that bond, and the surety will have to have agreed to provide the bond in the required terms. And as we mentioned earlier, that can be incredibly difficult at the moment. So in terms of collateral warranties, it's important to understand who the beneficiaries are and to ensure that this obligation isn't too wide. From a main contractor's perspective, as we noted earlier, it's important to understand who you are to provide the collateral warranties from, and to make sure this doesn't essentially extend to the whole of the supply chain. There are almost always strict timelines within which bonds, PCGs and warranties will need to be provided before the penalty of non-payment will kick in. So it's really important that the terms of these documents are negotiated and agreed before entering into the contract. And at the moment, as we've said, that's particularly important with regards to the performance bond, because the last thing you want is an obligation to provide a bond that you can't actually then procure. Probably the most obvious point is that wherever possible, the condition precedent to payment should be reduced to an entitlement on the client to withhold a reasonable sum rather than full withholding of payment. So finally from me, I'm going to look at existing site conditions and how those are dealt with under NEC. So in its unamended form, the NEC contract shares the risk for site conditions between the parties, with the contractor being entitled to a compensation event, which is the one shown on the slide, 61.112, where unforeseen physical conditions are discovered on the site. This compensation event is very often deleted. Clause 60.2 then sets out that this risk is shared on the basis that the contractor accepts the risk for site conditions that they should reasonably have foreseen, and that's based on the information provided by the client and information that's readily available relating to the site. And the client takes the risk on any unforeseen site conditions. Again, clause 60.2 is usually deleted and amended to pass the full risk of site conditions onto the contractor. These clauses, as with the example clause that we've put up on the screen, generally assume that the contractors have the opportunity to inspect the site, and that in reality is often not the case. Finally, under clause 60.3, the contractor is entitled to the benefit of the most favourable site information that they've been provided in the event that there's any ambiguity or inconsistency in that information. Again, this position is very often amended, as we've shown here, and that essentially changes it to a confirmation that the contractor isn't entitled to rely on any of the existing information that's been provided by the client. The overall effect of these amendments is that the contractor takes the full risk on all site conditions, whether those are foreseeable or not, and is not entitled to rely on any existing survey details when assessing the risk. So to summarise, whilst the NEC contract in its unamended form is very clear on how the risk for site conditions is to be shared, the contract is generally amended in a way that makes the contractor fully responsible for the existing conditions of the site. The definition of what amounts to a site condition is itself often very wide, so this can be a very high risk amendment for the contractor, and it's one that's often the subject of negotiation. What contractors need to bear in mind when negotiating this point is the common law position, which is where a contract is silent, the contractor is deemed to take the risk for adverse site conditions. So it's not enough to simply agree with the client to delete clauses 60.112, 60.2 and 60.3, but the express clauses should remain and be amended in a way that reflects the extent of the risk that each party is prepared to accept. As the contractor, if you're accepting a wide liability for site conditions and it's not feasible for site investigations to be carried out before the project is priced and programmed, in the very least, you should ensure that you have a direct contractual link back to the parties responsible for carrying out the existing site investigations. And that can be by way of a reliance letter, sorry, I've skipped forward, or a collateral warranty. I'm now going to hand you over to Hannah, and she's going to talk about some other important amendments.
Thank you, Sarah. So I'm going to move on to amendments that are important during the course of the works and why it is essential that the individuals running contracts are aware of the stringent requirements we see on a day-to-day basis. Now, the first amendment I'm going to deal with relates to a contractor's notice of a compensation event. But before talking about the common amendments we see to this clause, I want to look at the standard NEC clause itself. So even without amendment, the standard NEC clause as drafted is a condition precedent clause. Now, Sarah's mentioned these type of clauses in her slides, and I'm now going to spend a couple of minutes discussing what a condition precedent clause actually is. Now, in very simple terms, it is a clause in a contract which provides that performance of the contract as a whole or certain obligations under the contract will only come into force if and when specified conditions are met. It is the certain obligations under the contract that I'm going to be looking at now. If only certain specified obligations under the contract are expressed to be subject to a condition precedent, then the other obligations under the contract will remain in effect, but the relevant obligations only take effect when a condition is fulfilled. So if person A does not fulfill the condition, for example, to give notice within the requisite time period, then person B is not bound by the obligation on his part for example, to allow a change to the prices or the completion date. Now, condition precedent clauses are often argued about by lawyers, and they can sometimes be hidden away with clever drafting. It's important to note that no special form or words need to be used to create a condition precedent. In particular, the phrase condition precedent itself does not need to be used in order for the clause to operate in this way. However, it must be clear from the wording that the performance is conditional upon the specified event occurring. So a condition precedent clause should cover the following matters. Firstly, it needs to have a deadline for fulfilment. There needs to be a set date and not put the parties under an indefinite obligation. Secondly, the clause needs to set out the consequences of non-fulfilment. The clause needs to state what happens if the condition is not satisfied. Thirdly, the clause needs to set out the steps to fulfill that condition. So a condition precedent clause should specify exactly what is required for the condition to be fulfilled. So why is all of this important? Well, as I said earlier, the standard NEC clause that deals with compensation events is already drafted in such a way that if notice is not given, there is no change to the prices or the completion date. Now, this is arguably a condition precedent clause even without any amendment to it. The specific clause I'm talking about is clause 61.3, as shown on the slide, that if a compensation event is not notified by the contractor within 8 weeks of becoming aware that the event has happened, the contractor loses his entitlement to any change to the prices or the completion date. Beware, however, the period of time to give this notice is more often than not changed to a reduced period, commonly 4 weeks of becoming aware that the event has happened. Now, in addition, the NEC wording gives the contractor a partial get-out-of-jail-free card by saying that the notification is not required if the event arises from the project manager or the supervisor giving an instruction or notification, issuing a certificate, or changing an earlier decision. As you might expect, this wording is removed in most amended forms of NEC, so the contractor must give the requisite notice of the compensation event, no matter how it has arisen, otherwise there will be no entitlement to a change to the prices or the completion date. So how does this impact the parties to the contract? Well, if the contractor is seeking a change to the prices or the completion date, but the condition precedent clause has not been complied with, the contractor will not be entitled to the change claimed. It is really as simple as that. Now, it doesn't matter how strong the contractor's claim is. The position could be entirely clear-cut. However, if the contractor has not notified the project manager of the event in accordance with the condition precedent clause, the project manager is not obliged to increase the prices or extend the completion date. It is therefore key that those individuals who are running projects on the contractor side are aware of any condition precedent clauses in the contract, particularly in relation to compensation events, and ensure that the correct notices are given to avoid losing any entitlement under the contract. When in doubt, issue a notice. It is better for a contractor to issue a notice than not, to protect its position in the future. Now, we see contractors fall foul of condition precedent clauses frequently, and it can be easily avoided if those people actually running the works are aware of the notice requirements and the consequences if such notices are not given. I'd also suggest that project managers are aware of the requirements that must be met before changing the prices or the completion date, to avoid any arguments of waiver, for example, if changes are made despite the contractor not complying with these strict condition precedent clauses. This will help the client's position later on down the line when us lawyers get their hands on the dispute. Next up, everyone's favourite topic, payment. So the extent to which payment clauses are amended varies. However, it is safe to say that we very rarely see unamended payment clauses. Now, parties will most likely change the payment periods, but what I'm going to look at here are the amendments made to the NEC form specifically in relation to the contractor's application for payment. So the amendments we commonly see to the NEC requirements for an application for payment are set out on the slide. This is often a complete rewrite of the relevant clause. The standard NEC form just requires an application for payment to be issued at any time before each assessment date, setting out the amount the contractor considers is due at the assessment date. The application needs to include details of how the amount has been assessed and needs to be in the form agreed between the parties in the scope. Now, the amendment to this on the slide requires the application to be detailed and to be issued not later than 7 days before each assessment date. The application must also include sufficient information and documents to provide the project manager to verify the sum claimed. Further, the wording states that the application will be invalid if it does not comply with these requirements. Now, the contractor cannot simply issue applications for payment when it likes, setting out just the sum claimed and how that sum has been calculated. If the contractor does this, the applications would be invalid, resulting in no payment to the contractor for that interim payment cycle. Again, it is therefore key that the person issuing applications for the contractor is aware of the requirements and ensures that these are complied with, because if they are not, the contractor will not be paid that month. Now, it's also important that the project manager is aware of the requirements, so he or she doesn't inadvertently accept an application for payment when it is non-compliant with the terms of the contract. So, sticking with the payment theme, my next amendment is one that we regularly see if option C is utilised. Now, whilst this is a very specific amendment just to this option alone, it is an interesting one, so I'm going to just spend a couple of minutes looking at what it means in practice. Option C, as I'm sure you're all aware, is the target contract with activity schedule. Now, this option is most typically used where the scope of works is not yet fully defined, or on projects where greater financial risks are anticipated, and is intended to encourage transparency between the parties. Now, this in turn should enable more effective management of the works. Under option C, financial risks are shared between the parties in agreed proportions, with the client and the contractor agreeing a target. In the course of carrying out the works, the contractor is paid for its defined costs incurred in carrying out the works, plus a fee to cover overheads and profit. But at the outset, the parties agree a target cost, and on completion of the works, any savings or overrun are allocated between them in accordance with a predetermined pain and gain share mechanism. So option C, clause 54, sets out how the contractor's share is dealt with. In summary, it provides that the contractor share is calculated on the difference between the reimbursable price for work done to date and the target price, which is the total of the prices included in the activity schedule, adjusted to take account of the compensation events. Now, the difference is split into increments relating to the share ranges specified in the contract data. Each increment is multiplied by the appropriate share percentage set out in the contract data, and the products of these multiplications are then added together to give the contractor's share. Now, the project manager makes a preliminary assessment of the contractor's share at completion of the whole of the works, using its forecasts of the final price for work done to date, that is the defined cost plus the fee, and the final target price. Now, the project manager's final assessment of the contractor's share is made once the defined cost incurred by the contractor and the final target price are known. So that's the position as set out in the standard NEC contract. However, the amendment we frequently see to this mechanism is to remove the project manager's preliminary assessment of the contractor's share at completion, and instead provide that the contractor's share is assessed firstly at any assessment date before the completion date if the price for work done to date is greater than the total of the prices, and also at completion of the whole of the works. However, If at any assessment date before completion, the price for work done to date is greater than the total of the prices, the amount above the prices is not actually paid to the contractor until the final payment, which, if not amended, is either 4 weeks after the defect certificate is issued or 13 weeks after the issue of a termination certificate. Now, this prevents the contractor from receiving interim payments in excess of the total of the lump sum prices. This means that when the contractor's share comes to be calculated under clause 54 of option C, the client is never in the position of having to claw back a share of the payments paid in excess of the prices once the pain gain share has been assessed. Now, whilst this amendment makes commercial sense from the client's perspective, from the contractor's perspective, this does significantly change how the option C contract is intended to operate, from the contractor being entitled to a share of any cost overrun to the contractor not being entitled to receive payment for the difference between the prices and the price for work done to date on an interim basis, as this can be retained and not paid right until the final payment. Now, this may of course cause cash flow issues for the contractor, so it is vital that this amended clause is then passed on to any relevant subcontractors too. So this clause is not strictly an amended clause, but rather a new clause we commonly see added to contracts in an attempt to allow the employer to omit works and place them with an alternative contractor. So the wording is often included at the end of clause 14.3, which gives the project manager the right to give an instruction to change the scope or a key date. The additional wording, as seen on the slide, allows for any element of the works to be omitted and for others to be instructed to carry out such omitted works. If this does occur, the employer is not liable for any losses arising from the omission, and no change to the scope shall vitiate or invalidate the contract. So why is this clause important? Well, it potentially gives the employer the right to omit large parts of the works and give them to someone else without any recourse for the contractor. This gives the employer flexibility for the works, but it's not so great for the contractor if halfway through the project, the employer omits all remaining work, gives it to a competitor of the contractor, leaving the contractor out of pocket for its profit for the remainder of the works. Now, I say that this clause potentially gives the employer this right, as it doesn't seem the courts are too keen on these sorts of clauses, and it is at least arguable whether they would be enforced. There's two cases from the early 2000s that look at this point. The first is Abbey Developments Limited and PP Brickwork Limited. So here, the court held that the contractor had a duty to carry out the work it had contracted to do and a corresponding right to be able to do so. The employer cannot escape a bad bargain by the use of the omissions clause. The court went on to say that clear words are needed to enable the employer to remove work from the contractor simply to have it done by somebody else. Now, those words didn't feature in the contract in question between Abbey and PP Brickwork, but such wording would be included if the amendment on the slide was in. Now, the Abbey Developments judgment was approved in Stratford Say Estate Trustees and Archor Construction Limited. Now, in this case, the court held that the employer's power to omit works was limited, and the employer couldn't change the basic nature of the works by omission. However, again, there was no express wording in the contract between the parties allowing works to be omitted and carried out by another party, unlike the amended clause here. Now, regardless of whether it is arguable if the specific clause would be enforced, this is an amendment to look out for and for contractors to be mindful of. It may be one of those amendments that it is unacceptable to the contractor in question because of the huge level of uncertainty it gives. Alternatively, the contractor may wish to try and negotiate this clause to provide that the client can omit as much work as it likes, but if it does so, the contractor is entitled to be paid the profit it would have made on the omitted works. That's my 4 amendments done. I'm going to pass over to Ruth for the remaining 3.
Thanks very much, Hannah. So following on from the omitted scope, That nicely leads on to my first amendment, which we often see in NEC contracts, which relates to termination. So, and expressly termination at will. In order to understand the termination at will amendment, you really have to understand how termination under NEC works. So termination provisions are contained in section 9 of the NEC contract, and that deals with termination of the obligation to provide the works. It's the termination of the employment of the contractor, or in case of a subcontract, the subcontractor, which is terminated, and not the whole of the contract, i.e. you don't rip it up and pretend it never existed. There are a number of clauses which survive termination, i.e. you are still liable for defects. So I'm just going to very briefly set out how the termination provisions work under the NEC, so that you can gain an understanding as to why the termination at will provisions and the amendments are so important. So I'll be looking at clause 90, which deals with notification of the termination and the termination table. 91, which deals with the reasons. 92, which deals with the procedure. And 93, which deals with assessment. Now, I've capitalised the reasons, the procedure and the assessment for a reason, and you'll see that when we come on to the termination table. So starting with clause 90, there is a two-stage notification process. There's a notification of the termination, and then there is a termination certificate which is issued by the project manager, confirming whether or not the termination is in accordance with the contract. Now, what clause 90 also has is the termination table. And as 90.2 there says, a party may terminate for a reason identified in the termination table. The procedures are followed and the amounts due on termination are in accordance with the termination table. You'll recall on the last slide that I referred to the capital R reasons, I referred to the capital P procedure, and I referred to the capital A assessment or amount due. They're very important because the contract sets out those reasons, those procedures, and those amounts due. And this table is your first port of call when you're looking to terminate, to see what the effect and the procedure is relating to that reason to terminate. If I then come on to the next slide, clause 91. NEC contracts are very formulaic. They do follow a set pattern. Clause 91 deals with your reasons, so your capital R reasons. There are reasons listed 1 to 22, and they include things such as insolvency. They include a reason for substantially failing to comply with obligations under the contract, always a little bit of a grey area, always open to some interpretation, and also a reason that you hadn't been paid an amount due within 13 weeks. Now, what you'll notice is that all of these reasons are fault-based reasons, so you have to be able to identify and prove the fault to be able to rely upon it to therefore terminate. The other issue that you can see is that many of these reasons require a party to wait a significant period of time in order to terminate. So on the amount due 13 weeks, there are other reasons as well in the contract which have a 13-week kind of pre-period before termination. The other issue is that a lot of the capital R reasons require a pre-notice. So substantially failing to comply with the obligations, R11, that normally requires a pre-notice of 4 weeks. So you have to write to them to give them 4 weeks notice to say, we consider you're substantially failing to comply with your obligations, namely you are failing to do X, Y, Z, A, B, and C. The purpose of that pre-notice is then to give the party that 4 weeks to rectify the failure to comply with the obligations. If they rectify it, then you have no right to terminate, and you are back to the drawing board in the event you'd like to terminate. Turning then to clause 92. Clause 92 explains what those procedures are, so the P1 to the P4. P1 deals with the use of plant and materials on site, and Ps 2 to 4, where one or more of the following apply, relate to what happens to the equipment. And just if I were to just quickly go back to the slide that's got the termination table on it, when you hear me talking about the P, you now understand the relevance of it, because if you terminate for a particular reason, the termination table then dictates the procedure that you are going to adopt on termination. So I'll just flick back to that now quickly. So we've dealt with the procedure, and then the important thing that everyone's always concerned about is the money. So on the money, clause 93 deals with the assessment. And essentially what it says is that there are 4 possible ways to assess the account. When I say 4 possible ways, it's really 4 heads of assessment. And again, these 4 heads of assessment, A1 to A4, determine payment on termination and what is and is not going to be due. A1 and A2 are fine. They value the work at termination effectively. A3 is a head for a deduction for the forecast costs to complete. So an employer will want the opportunity to deduct the forecast costs to complete, especially in insolvency circumstances where it's likely to cost them a lot more money to employ another contractor to come onto site and to finish those works. If they terminate, they will want the ability to be able to deduct the forecast cost to complete. The main one here is also A4. Now, A4 is basically payment of your loss of profit in the event of termination. So, and that is your payment of your fee percentage. Now, as a contractor, under a main contract, if you are terminated, you will want to receive your loss of profit. The client will not want to pay you loss of profit if the termination is by reason of default. So in some instances in the termination table, A4 does apply, and that is what I'm uniquely going to come on to in relation to the amendments that we see. So the amendment that we often see is in relation to termination at will. I'll come on to what the NEC3 contract used to do, because that used to embed the right to terminate at will into clause 90. But in respect of NEC4, there is now a new option X11. Just before I come on to that, we are asked to advise on termination time and time again. Clients come to us saying, I've had enough of the contractor, I want to terminate, it's not going well, I'm not sure if I've got enough to pin on the substantially failed to comply with the obligations, I don't want to serve a pre-notice and have to wait 4 weeks, how do I get them off site? This is when we open the contract and look to see if there's an option X11 or an equivalent amendment, which gives the client the right to terminate at will. And by that, I mean decide to terminate and not have to prove and identify a fault. Now, what option X11 is often amended. I've talked you through the reasons, which obviously they don't apply here because it's just a termination at will. I've talked you through the procedure, and really the most important one is the payment. And as you can see, the option X11 here is amended in track changes, and it removes A4. A4, which means if you terminate at will and you choose to do so without having to provide any kind of valid default reason, then under this amendment, that contractor is not entitled to loss of profit. And just in case it isn't abundantly clear, the amendment then also includes, and for the avoidance of doubt, the client will not be liable for any of the contractor's loss of profits, loss of opportunity, etc. So you may think, well, what is the issue with this? Does it really matter? Well, when you've signed up to a building contract that includes a termination at will, and often the notice provision will be pretty short in relation to terminating, it could be, termination within 24 hours, that is going to potentially put you in a difficult position if you've signed up to that and you haven't got an opportunity to claim loss of profit, especially if you have then engaged your supply chain under a similar form of contract, and firstly, you haven't got a termination at will clause in your contract, and secondly, if you do have the option to terminate, then you have to potentially pay them loss of profit. So that is the difficulty, and that is the position you don't want to be in as a contractor, where you are terminated at will under your main contract, you have no opportunity to claim loss of profit, and then your subcontract, you haven't got the same downstream provision, and you are then liable for your supply chain's loss of profit on termination. As I said before, NEC4, we've got the new option X11. Clause 90.2 had a similar provision in relation to termination at will by the client for any other reason other than a capital R reason, and the effect of this was the same, really, to remove the right to be able to claim loss of profit. The next slide that I will now come on to is in relation to changes in the law. The basis upon which the party who takes the risk for change in the law is often amended from the standard form position. The NEC standards forms have a specified date where the risk for changes in law shifts from the contractor to the client in the standard form. And in the NEC, it's the contract date that is relevant. And as a result of the risk shifting to the client, the employer will then be liable for the cost and time implications of any change which is necessitated as a result of a change in law. So the amendments that you can see on the screen try and water down that risk to the client by saying that there will only be a compensation event in the event that such a change in law could not have been reasonably foreseen by a competent and experienced contractor as at the contract date. Now, the X2 is a secondary option, so you actually have to include it within your contract data for it to be incorporated. There is no definition in the NEC contract as to what amounts to law, and the NEC guidance note suggests it would include a national or state statute, ordinance, decree, regulation, including building or safety regulations, and a bylaw of a local or other duly constituted authority or other delegated legislation. And general dictionary definitions emphasise the need for a law to be issued by a state-sanctioned authoritative body and to be enforceable. So as I've said, the amendment on the slide, as a caveat, it waters it down, and the risk has to be adjudged by what a competent and experienced contractor would have foreseen. So there's no good in the contractor saying, well, I didn't foresee it. So, you know, as far as I'm concerned, the change in that law is the client risk. That is not relevant. It's what a competent and experienced contractor within the UK construction industry would have foreseen as at the contract date. Turning now to fluctuations, this is one which actually we don't see that heavily amended, but is one that has been considered a lot by contracting parties over the last couple of years. Since the cost of materials and labour skyrocketed, those who signed main contracts a few years ago are now dusting off their contracts to see if fluctuations apply. Unlike JCT provisions, which provide options to deal with fluctuations, NEC is far more limited. So under NEC, there's an option X1. Again, it's a secondary option clause, which the parties have to expressly incorporate into the contract data. One thing I'll say is this clause is not normally amended, and it does actually only provide for one option for fluctuations. It's based on index price adjustment against inflation, so it is actually pretty limited in use, and is certainly pretty hard to administer. I've in fact just had one client ask me a question about an option X1 in one of their contracts, and having tipped through it, in fact it is amended, looking at the detail, it does look pretty tricky to administer. So the other thing about fluctuations, they might be slightly off point, but in relation to JCT especially, people that have been pushing for fluctuations in their contracts, just be aware that they can go down as well as up. And I know that having spoken to quite a few people in the market recently, actually there is a bit more of a supply of labour at the moment, so the cost is potentially coming down. But maybe I'll let you be the judge of that. Thank you very much. That brings our kind of formal session to an end. Thank you very much for attending. We've got kind of a few minutes to deal with some questions that we've had. Just before we do, please do join us for the next By Archor webinar on Thursday the 19th of October at 12:30. We Further details will be found on the website. I think the link is going up very shortly onto the SciC's website for booking. Topic is TBC, but hopefully it will be just as interesting as today, if not more so. But yeah, please do sign up, and we do look forward to seeing you then. Just in relation to questions, as I say, we've literally got kind of a couple of minutes. And you know, one thing I think would be quite helpful to touch on, which I know that Sarah had spoken about this morning, is in relation to the bond market and difficulties in providing security. And I know that has kind of led on quite nicely to kind of PI insurance issues. I just wonder if maybe, Sarah, you wanted to very briefly just talk about what you found with that.
Yeah, absolutely. So I work on the non-contentious side of things, so I see a lot of contracts, a lot of bond wording, and it's a huge issue at the moment. The bond market is incredibly difficult, as I'm sure many of you know, if you've tried to apply for a performance bond. And coupled with, I mean, that's really an effect of the high amount of insolvencies in the market at the moment. And the sureties having a bit of a knee-jerk reaction to that. But coupled with that, the other issue that we're seeing that we didn't touch on in the presentation is around PI insurances. So it's not unusual to see in contracts specific levels of PI insurance, not only for the main contractor, but also an obligation on the main contractor to procure that the supply chain provides PI insurance at very specific levels. And the issue is that the PI insurance just isn't available at the moment. Many elements of the supply chain who would have had a decent level of PI on an each and every claim basis just simply can't obtain it, or can't obtain it for a cost that's reasonable to them. So there's a lot of aggregate cover in place. And from a main contractor's perspective, what you need to look out for is a bit of wriggle room in the contract, either not having that specific level of PI for your supply chain set out in the contract, or having the ability to negotiate that with the client, or probably more likely with the funder or any other beneficiary of a collateral warranty going forward, so that it's not an absolute obligation and not tying up to something that you just purely can't then deliver as the contract moves forward.
Okay, thank you, Sarah. We are literally very short of time. We've got 2 minutes. One thing I was just very quickly talk about was, again, it's being discussed quite a lot in the market at the moment, are insolvencies, how can we protect ourselves. We kind of talked about that in the office a lot recently, and I think the view is shortening payment terms is one thing that we've been looking at. People have been asking about escrow accounts as well. In the absence of being able to obtain bonds, increasing retentions with the larger chunk that are being issued on being payable on PC. So just trying really to protect yourselves in the market. That, you know, there have been a few kind of large insolvencies in recent times. So yeah, it's just trying to ride a few waves at the moment, I think, for various people. But I'd just like to say thank you very much. Someone's asked if the slides are going to be on the website. Yes, they will be on the website, and they will also be on the SciC's YouTube channel as well. So please do view at your leisure. But I'd just like to say thank you very much for joining us today. We've had an excellent number of attendees, so we're really grateful, and we look forward to seeing you in October, and have a good summer. Thanks very much.
Thank you.